Hey class, welcome to week 6. This week we are going to examine delegation both within the federal government and also outside of the government when the government delegates to non-governmental entities, a process known as outsourcing, procurement. It's known by a variety of different terms. So that is what we are going to explore this week. But before we get started, I want to pour one out for Justice Ruth Bader Ginsburg. She passed away right around the time that Shabbat, the Jewish Sabbath, began on Friday. That was a special Shabbat because it was the beginning of Rosh Hashanah, which is the Jewish New Year. And according to Jewish tradition, a person who dies on Rosh Hashanah is a tzaddik, a person of great righteousness. And Justice Ginsburg often cited her Jewish heritage as a source of her passion for the plights of minorities and women. And she really did fight fiercely to advance and defend those rights. And in doing so, she helped protect the rights of all Americans, regardless of gender, ethnicity, color, or some other classification. I did struggle on whether to comment on her passing here in this class, but since we are a law-based class and Ruth Bader Ginsburg was a brilliant jurist, I did just want to make mention of it. And as we say in Judaism, may her memory be a blessing. Before we get into the substance for this week, I do want to remind you to start thinking about a topic for your policy analysis memo if you have not already. A prospectus about your topic is due at the end of week 7. That can just be a simple statement of your topic and 3 potential resources. That would be sufficient. Now remember, for your actual memo, you need to focus on administrative law, not legislative decisions. So you can discuss how an agency should implement a statute, create a policy, but don't write about whether Congress or a state legislature should pass a particular law. Your memo will need to explain why the issue is important, provide enough background information to orient the reader, identify at least 2 policy options, and then make a recommendation about which option you think the decision maker should take. Please review the policy analysis memo guidelines. Let me know if you got questions. If you are not sure about a topic, consider what you would like to change in a government agency. If you were in charge of a particular government agency, what would you do differently? You can also review the news items that might give you some ideas, and I'm happy to bounce around ideas with you if you feel like you're stuck or you're not really sure what a good topic would be. Okay, now let's move on to the substance. Let us take a closer look at delegation within the government. So you already know the basics of this because we've discussed how Congress delegates executive, quasi-legislative, and quasi-judicial authority to executive branch agencies. And as we have discussed, it is an agency's enabling statute that defines the agency's mandate, how the agency is structured, and provides the agency's authority to act. Congress can also direct agencies to take on additional responsibilities, give them additional authority by passing additional statutes that the agency has to implement. Congress primarily delegates executive authority to agencies. Agencies exist to enforce and otherwise carry out the law. And because agencies sit within the executive branch, there is no separation of powers problem if Congress is delegating them executive authority. Because they do sit in the executive branch, we as the public tend not to really think of agencies as being engaged in legislative or judicial activities. But Congress can and does delegate both quasi-legislative and quasi-judicial authority to executive branch agencies. The quasi-legislative delegation allows agencies to issue regulations, and the quasi-judicial delegation allows agencies to hear and resolve certain disputes within their area of authority. Given the size and complexity of our nation, we need agencies to hold those powers because without them, the process of governing would simply grind to a halt. However, the fact that agencies in the executive branch do carry out legislative and judicial functions is a separation of powers issue. So while we need agencies to operate in this fashion, we also need to hold them accountable and make sure that there is not a violation of our constitutional requirement of separation of powers. Now, I do not mean to imply that Congress can or has delegated all of its legislative functions to agencies, nor has it delegated all judicial functions to agencies. Congress cannot delegate the essential functions of either the legislative or judicial branches. And we find these essential functions in the Constitution. So you can see I've got them here on the screen. Some essential legislative functions include regulating commerce, borrowing and coining money, and declaring and fighting wars. Now that last one, declaring and fighting wars, is important because there is a debate today over whether Congress has unconstitutionally delegated some of its military functions to contractors who work in the defense and intelligence community. And we'll talk about that a little bit later. For the judicial branch, essential functions include things like holding office for life, deciding all cases that arise under the laws of the United States, and making judgments as to both law and fact. So this means that while Congress can create agency hearing boards and appoint agency judges to hear cases, Congress can't appoint agency judges who hold office for life, they cannot hear constitutional cases, and they cannot render judgments in any area that is not directly related to the agency's authority. While Congress can delegate this quasi-legislative and quasi-judicial functions to an agency, it cannot delegate in such a way that it gives one branch oversight or control of an agency that is performing the functions of another branch. So for example, Congress can delegate quasi-judicial authority to an agency so that it can hold hearings and issue decisions, but Congress is not the one who gets to oversee those hearings and decisions. That is a judicial branch function, and so only the judicial branch can provide oversight that relates to judicial authority. That is why agency decisions can be appealed into our court system. Similarly, Congress can't delegate too much of its own legislative authority to agencies. It has to provide guidelines for agencies to follow. So this slide should look familiar. You saw a similar version of it in week 4 when we were talking about agency discretion. Because the Constitution vests all legislative powers in Congress, Congress isn't authorized to simply hand those powers over to another branch. That would be unconstitutional, and it is prohibited by the Non-Delegation Doctrine. That's the doctrine that states that one branch of the government must not authorize another branch to exercise a power or function that it is constitutionally authorized to exercise itself. Now, as I said previously, there's a fairly heated debate over whether the framers actually had a problem with the idea of Congress delegating its powers to another branch, but let's just assume that they did. Congress, as we know, cannot be an expert on all issues, and so it seeks assistance from other branches, including agencies within the executive branch. In practice, this means that Congress can delegate a portion of its authority to an agency so long as Congress is providing guidance to the agency and setting boundaries for the agency's authority. So this is the intelligible principle. And again, you can think of the intelligible principle as a sandbox that Congress creates. The agency can only play, that is regulate, within the confines of that sandbox. Outside the sandbox, the agency's got no authority to regulate. So the non-delegation doctrine allows courts to strike down laws passed by Congress when, in the court's view, those laws give the executive branch too much legislative authority and Congress provides too little guidance to the executive branch on how to use that authority. I am not going to get too much into the history of the non-delegation doctrine, but it did start back in 1911, which is when courts really recognized that Congress just didn't have the time or resources to legislate every situation. I was going to say that Congress didn't have the bandwidth, but I don't think that bandwidth was actually a term back in 1911. So prior to the Supreme Court case of U.S. v. Grimaud in 1911, agencies found it really difficult to operate because they had such limited authority. They did not have that quasi-legislative authority that they have today, so they weren't really able to issue regulations. Or if Congress had granted them that quasi-legislative authority, courts would strike down those regulations and would find that the non-delegation doctrine prevented Congress from giving that authority to agencies. But by 1911, it was just obvious that Congress could not foresee every situation, nor could Congress be a subject matter expert in all fields. And so in the Grimaud case, the Supreme Court decided that as long as Congress created the overall policies, the scope of the law, then agencies could use their expertise to create regulations that filled the gaps where Congress just did not have sufficient information to legislate. And that appeared to kind of be the end of the non-delegation doctrine. But then the Great Depression led to the creation of numerous agencies with very, very broad delegations of authority. So this was an attempt by both the President and Congress to respond to a crisis situation and pull America out of the Depression. But at least some of these delegations to agencies, and a lot of these were agencies created by the New Deal, these delegations really were terribly broad. There were agencies that simply had too much authority and they were not constrained in their actions. And so in 1935, the Supreme Court reviewed the National Industrial Recovery Act of 1933, or NIRA. That was a labor and consumer law. And through NIRA, Congress had authorized the president to regulate industries to make sure that there were fair wages and prices, fair prices, that would stimulate economic recovery. So the court took a look at that and invalidated some of these overly broad delegations of authority to agencies. So in, for instance, the Panama refining case, Congress had granted the president the authority to prohibit interstate shipment of petroleum that was in excess of certain quotas. But in that case, the court found that Congress provided no guidance, nothing to constrain the president's exercise of the power to basically create, rather than just enforce, the laws. The last case of true importance for the non-delegation doctrine was the Schechter Poultry Corporation case, and that invalidated another NIRA delegation where Congress did not provide appropriate guidance to the executive branch. So we know that the sale of food is often regulated. But NIRA allowed trade groups and companies, so non-governmental organizations, to write local regulations or codes about different types of regulation. And NIRA, the law passed by Congress, granted the US president the authority to give those codes, these privately written regulations, the force of law. So these regulations included price and wage fixing, as well as requirements regarding the sale of chickens, be they sick or healthy. In the Schechter poultry case, which is also known as the sick chicken case, the Schechter family was selling chickens in Brooklyn. The Schechters were a Jewish family. They were primarily selling their chickens to other Jewish people and Jewish butchers. This was intra-state commerce. Eventually, the Supreme Court found that the Schechter company was just not engaged in anything approaching interstate commerce because it was all so localized within the city of New York, specifically within Brooklyn. At some point, the federal government had decided that the Schechter Poultry Corporation was violating some of these NIRA regulations, and the government filed a frankly insane number of charges against the company. I think it was something like 80 of them altogether. That was eventually reduced to a more manageable number, but still the charges included selling a sick chicken and also selling 2 chickens that had not been inspected per these private regulations. So the Supreme Court examined NIRA's grant of authority to the executive branch and determined that Congress just had never provided any standards or guidelines. So in practice, that meant that government agencies could really do whatever they wanted, enforcing some regulations here and others there. Congress had not created a sandbox, and so these agencies were really unfettered in their discretion. So the delegation was unconstitutionally broad, and that led to the court invalidating portions of NERA. So Schechter was the last case to invalidate a delegation of authority based on the non-delegation doctrine. And since the late 1930s, courts have been pretty lax in applying the non-delegation doctrine. Basically, so long as Congress established the overall policy and provided agencies with an intelligible principle, courts just accepted that agencies were authorized to create regulations to fill gaps left by Congress. And for practical reasons, courts are pretty loath to apply the non-delegation doctrine because if that doctrine had real teeth, it would cripple the bureaucracy and it would make it much, much harder for government agencies to regulate harmful conduct and harmful substances. Additionally, Congress just does not have the manpower or the expertise to regulate the broad range of issues that constantly arise in the modern world, and our courts know that. So today, courts pretty much remain unwilling to apply the non-delegation doctrine, but it has received some renewed attention lately. Most recently in the case Gundy versus United States, which was a 2019 Supreme Court decision. And Gundy dealt with part of the Sex Offender Registration and Notification Act, that's SORNA, that allows the Attorney General to basically specify the applicability of mandatory sex offender registration requirements. And that applies even to sex offenders who were convicted before SORNA became law. So despite having been convicted prior to SORNA, Gundy still had to register as a sex offender because the Attorney General had the authority to decide, that SORNA applied to all sex offenders regardless of conviction date. This did sort of make the law retroactive. It was an ex post facto law. Gundy argued that Congress violated the non-delegation doctrine by giving the Attorney General unguided and unchecked authority. The Supreme Court really struggled with the Gundy case on several levels, and it only reached a plurality opinion, so not enough justices agreed on the substance of the decision to have a majority opinion, but enough of them agreed on the outcome. As to the non-delegation doctrine, the court held that because SORNA guided the Attorney General to eventually apply those registration requirements to all sex offenders, SORNA did not violate the non-delegation doctrine. The court found that Congress had provided enough of an intelligible principle that its delegation of authority passed muster, although really that was very close. It barely passed muster. Justice Neil Gorsuch has long signaled a desire to revive, or at least consider reviving, the non-delegation doctrine. And his vigorous dissent in Gundy, really stated that Congress was giving the Attorney General basically the power to write his own criminal code. In addition to not being able to delegate too much of its legislative authority, Congress also can't delegate too much judicial power to agencies. So Article 3 of the Constitution, that sets up the judicial branch, provides that federal judges are appointed by the President, confirmed by the Senate, and serve for life. Congress has no authority to create a duplicate setup within the executive branch, nor does Congress have any authority to assign tasks to federal judges. Think back to our review at the start of the semester of the law. We've got public law and private law. So in private law cases, which are suits between private individuals or organizations, Congress can't delegate any of that judicial power to non-Article 3 officials. That judicial power remains within the judicial branch as created by Article 3 of the Constitution. But in public law cases, which are suits between the government and a private individual or organization, Congress can delegate certain judicial powers to agencies, and specifically to agency hearing officers. However, Article 3 courts retain the right to review those agency decisions. So since Article 3 creates the judicial branch, and that is where we find all of what we consider to be our judges, to whom does Congress delegate these kind of certain judicial powers? Well, Congress creates judge-like positions. We call these Article I judges because they're created by Congress with its Article I powers and then placed into the executive branch and sometimes into the judicial branch. If these Article I judges are placed into the judicial branch, they are known as magistrates, and they are subject to Article III judge oversight. So that is basically a magistrate reports up to what we would think of as a real judge. Magistrates were created by the Federal Magistrates Act. They were created to assist federal judges because of the just overload of court cases. And although magistrates were created by Congress, they are entirely under the control of the federal judicial branch. Currently, there are about 250 full-time magistrates. They get appointed by district court judges, and they serve 8-year renewable terms. Similarly, bankruptcy judges, those positions are also created by Congress. And bankruptcy judges are permitted to adjudicate certain private law claims that relate to the bankruptcy proceeding. And that is both for reasons of efficiency and also because there is expertise required in applying bankruptcy law to some of these private claims. Administrative law judges, or ALJs, are agency officials. They're these Article I judges who are put into the executive branch to oversee agency hearings. So almost every agency has ALJs. The Social Security Administration, for example, has 1,300 ALJs. They handle over 500,000 cases per year. And like bankruptcy judges, ALJs get to adjudicate some private rights in the course of adjudicating public rights. And they can do this so long as Congress has created the policy area with a comprehensive scheme of regulation. So as an example, let's take radio station regulation. If a radio station wants to sue the Federal Communications Commission, the FCC, the station does that pursuant to FCC regulations, and the complaint gets heard by an FCC administrative law judge. So that's the public law part. But that FCC administrative law judge can also adjudicate a dispute between the radio station and one of its competitors, so long as that private dispute is a small piece of the larger public dispute between the radio station and the FCC. And we will discuss ALJs further when we examine agency formal adjudications. So this is just kind of like a little intro to your ALJs. Okay, now let's talk about a different type of delegation. When the government delegates some of its authority to an entity outside the government via a contract or some other agreement. So outsourcing, it goes by many different names. Contracting, outsourcing, procurement, acquisition, there are a lot of different names for it. But all of these activities involve the government obtaining some type of goods or services from an external entity. Often a private party, but it could be a state government agency. It could be a university, a public university, for instance. Office of Management and Budget Circular A76, which was developed back in the mid-60s, notes that the long-standing policy of the federal government has been to rely on the private sector to supply commercial goods and services. And A76 also speaks of the need for competition in the acquisition of those commercial goods or commercial services so that the American people get the maximum value for our tax dollars. So government contracting has been around for a long time. On the screen, you can see an RFP, that's a request for proposals, from 1816, and that is for bricks to build the Capitol building in Washington, D.C. But government contracting was around long before the United States existed. Government contracting has a background in military and empire building operations. So it's been around for thousands of years in a variety of empires and kingdoms throughout the world. For the Western world, government contracting began in ancient Rome, because the Roman Senate had to supply its outposts and its military as the Roman Empire grew. The sheer size of the Roman Empire required a formal procurement system, with government buyers and various private distributors who were paid by the government, in this case, the Roman Senate. That Roman system was adopted and refined by the English, and the English system of military procurement was then adopted in the American colonies prior to the American Revolution. Now, during the American Revolution, the Continental Congress had no authority to tax the colonies or pass binding laws, and this created a huge problem, as you might imagine, for the war effort. In order to try to get around this, the Continental Congress appointed quartermasters. Those quartermasters were responsible for acquiring and distributing goods to help the war effort. But because they had no official ability to obtain funds on behalf of the government, they really struggled to make purchases. Those quartermasters also had many layers of purchasing agents who were supposed to report up to them. But those purchasing agents were not opposed to accepting bribes, and they often awarded contracts to their friends and families. Eventually, the Treasury Department became involved, and it became the federal government's centralized purchasing authority. Philadelphia merchant Robert Morris, that's who you see there on the screen, he really worked to overhaul the system, and he put in place many procedures that we have in our current system. So for instance, Morris required government contractors to respond to formal invitations for bids and requests for proposals. He insisted on doing business with responsible contractors only, and he required that government agencies obtain contract terms that benefited the public. We also had the U.S. Constitution, which created a stronger federal government, and it continued, the government continued to grow in size, power, and responsibilities as the country expanded westward. So Congress needed contractors to head west, as Americans were heading west, and so Congress set up a system to allow for more competition in the contracting process. Unfortunately, it did not adopt all of Morris's procedures. Instead, it put a system in place that allowed the government to make advanced payments to contractors. And a lot of those contractors happily pocketed the money and disappeared into the Western territories, figuring that they were far enough away from Washington that they were not going to get caught. So this was obviously not a great system, and towards the end of American westward expansion, modern contracting practices evolved, including the use of good faith estimates, as well as using government-furnished materials. That was particularly important for military contractors because Congress wanted to ensure that the U.S. military was receiving high-quality goods and that all of these goods were consistent. So contracting procedures also evolved with manufacturing techniques. So as manufacturing improved, the procurement system improved. So during the Industrial Revolution, Congress decided that government officials could not personally benefit from contracts. Congress implemented these formal bid and proposal requirements. Congress required agencies to contract only with appropriated funds, so funds that they actually had that Congress gave to them. And during the Industrial Revolution, the Army put together general regulations that were the precursor to today's federal acquisition regulations. So then we get to the Civil War, and that really stressed the American procurement system to the point of breakdown. The military just began ignoring contract requirements, kind of went back to bribery and nepotism. And congressional investigations led to the passage of the False Claims Act after the Civil War. So it was after the Civil War that our modern procurement system really started to develop, including things like requiring contracts to be in writing and signed by both parties. World wars through the Cold War, Congress really relied on sort of typical military contractors to handle base camp services, to manufacture equipment like tanks and weapons. So it was really focused more on contractors providing stuff that required manufacturing that the government did not have. But eventually, as computer technology developed, particularly during the Cold War, the government started hiring IT service contractors, so people to deal with technology. And today, we really rely on contractors. The federal government really relies on contractors, and particularly within the military and intelligence communities, and that would include the Department of Homeland Security. So today, the military is no longer relying on these traditional defense contractors, but is really involved in sort of a wholesale outsourcing of military services. So rather than just have people build aircrafts and aircraft carriers, they've now got contractors operating in battlefields, often making operational decisions. And the intelligence community as well is incredibly dependent on contractors, and that's something that we're going to cover in this week's discussion. So the next time that you look for articles to post on our news items board, keep an eye out for stories about government contracting, because I'll bet that you will see quite a number of them. And you'll see a lot of them because government contracting is hugely important, in part because it is everywhere. So prior to the war in Afghanistan, the federal government spent over $200 billion per year on government contracting. And at the height of the Iraq War, the second one, the government was spending about $537 billion. During the Obama administration, government contract spending dropped slightly to just under $500 billion. These are billion with a B. But federal spending on contractors has risen for the past 3 years and now hovers around $600 billion. So every agency contracts with private companies to do something, be it clean the buildings and take out the trash, to build fighter jets and huge warships. Overall, there are somewhere around 300,000 contractor organizations, so contractor companies, and around 8 million contractor employees throughout the federal government. And given the scope of government contracting, it shouldn't be too surprising that government contracts are at the heart of many private party disputes with the federal government. Contracts are going to be one of the main reasons that federal agencies wind up in court. More worrying, though, is that some of our federal agencies are now operationally dependent on contractors. The Department of Defense and the Department of Homeland Security almost certainly could not function if they were suddenly deprived of contractors. All right, so what does the government buy? It buys all kinds of stuff. So clockwise from top left on the screen, you've got the launch of NASA's Cassini satellite, which was built and operated by contractors. There is a tsunami detector, also built by contractors, military drone, built by contractors, some purple gorillas that the city of Denver purchased, presumably to keep up with its large animal statue obsession. I've got an image of Saturn, also from the Cassini mission. That image was taken by scientists at universities and nonprofit research institutes. Then we've also got things like fighter jets and huge ships. But the government buys everything from pencils to milk to cars to whole buildings to space telescopes. When the government buys very simple items, pencils or milk, these are usually purchased from the lowest bidder, whereas more complicated items are usually purchased by the best overall offerer. So simple items, you buy it on the basis of price. Whoever's got the cheapest price is going to win. But complicated items, obviously, we don't want our military personnel using something that was simply purchased because it was the cheapest thing that the government could buy. And so more complicated items are the bidders, the contractors, are selected based not just on price, but also on a variety of technical qualifications. Now, my favorite thing that the government buys is research. The government funds research through grants, contracts, and cooperative agreements. There is an excellent chance that most of your professors have some type of research grant from a government agency. The federal government invests somewhere around $150 billion each year in research and development at federal laboratories, which are usually run by nonprofits, as well as universities and other nonprofit research organizations. Federal funding for research is especially important in areas where the private sector does not have a sufficient interest in funding the research itself. So basically, the federal government takes care of paying for fundamental research that paves the way for both scientific advancements and commercialization. So it helps the American public and also helps companies. According to economists, the return on investment for publicly funded scientific R&D is somewhere between 30% to 100%. Some of those economists actually say that the return on investment exceeds 100%. So for every dollar that the federal government spends on research, it's actually getting back something along the lines of a $1.25. We, the public, benefit directly from this government-funded research. It is thanks to NASA that we've got wireless headsets, camera phones, comfy sneakers, LED lights, baby formula, and dustbusters. And that's just a small list of things from one single agency. We've got digital data storage, fluorescent lights, communications and observation satellites, advanced batteries that wind up in our electric cars, modern water purification techniques, supercomputers, those things we got from the Department of Energy. So those things that I've listed between NASA and the Department of Energy, that government-funded research has provided things that we use every single day. I'll give you one more. DARPA, which is the Defense Advanced Research Projects Agency, basically gave us the internet. It started as ARPANET, and while Al Gore was widely made fun of for saying that he invented the internet, what he was actually saying is he was part of the group that funded ARPANET. So his take on that was somewhat misconstrued in the media, but he did actually have a role in helping us get the internet. Now, the power to make purchases is not in the Constitution. The Constitution is silent as to the federal government's ability to buy goods or services. But if you think about it, all of the powers enumerated in the Constitution would be pretty useless without purchasing power. The government needs to buy goods and services to carry out all of its enumerated powers and duties. And in the 1800s, the Supreme Court recognized that purchasing power flows down to individual executive branch agencies. However, we always want to be accountable in the use of public funds. And so every purchase by the government has to be traced back to authorizing legislation, which permits the agency to purchase certain items, as well as appropriations legislation, which is how Congress provides the agencies with actual funds to make those purchases. Additionally, all purchases of goods and services have to be properly documented. You got to be able to, to audit them. So the government can buy stuff, and the government does buy stuff, but why? Well, the government makes purchases from private companies because it lacks expertise in particular areas. That could be running a dairy, building ships, providing daycare services. Additionally, the government might need additional help, particularly when responding to emergency situations, and so it will call on contractors to provide supplies and support personnel. Every time FEMA has to swing into action because of a hurricane or fires or other natural disasters, a lot of contractors also become activated to help out in that emergency response. When it comes to commercial goods and manufacturing, the private sector is almost always more efficient than the government. The government, we don't need our government to own manufacturing plants to make pens or cars or clothing and so on. When it comes to services, though, it is unclear if the private sector is more efficient than government personnel. So studies show that for day-to-day services, things like custodial services, the private sector is more efficient. But when it comes to military and law enforcement and correctional services, outsourcing does not actually provide a lot of bang for our buck. It can actually be more expensive than having the government provide those services. And, as I said, since the start of military operations in Afghanistan, Iraq, and the Middle East generally after the terrorist attacks of 9/11, the government has come to rely very heavily on private military contractors and private intelligence contractors, and they do come with their own special concerns. But before we get into that, let's take a look at acquisition under the federal government's old procurement system. So prior to 1994, the feds operated under this old procurement system, which was absolutely chock full of gobbledygook government speak. So for example, on the slide, you can see a small portion of a GSA solicitation from 1993. So the GSA was buying a Type 1 glass square 4.5-inch 114.3 millimeter ash receiver that had to include a minimum of 4 rests spaced equidistant around the periphery, aimed at the center, molded into the top. Those rests had to be sloped towards the center of the receiver, blah, 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 blah. They also had to basically try to smash these receivers with a steel center punch, ground to a 60-degree included angle, to see when breakage occurs. Okay, so that's a lot of gobbledygook right there. That went on for 9 pages. And what did the GSA obtain through this solicitation? Ashtrays, heavy glass ashtrays. And actually, what the GSA obtained were really expensive, heavy glass ashtrays. All that the GSA wanted were ashtrays that were heavy enough that if they accidentally got knocked off the table or whacked with something, they wouldn't shatter and injure people. But instead, the GSA got these super expensive ashtrays because there was no company that was manufacturing ashtrays that tested to the extent, to the minute detail that GSA was requiring. So this was a terribly inefficient system. It wound up costing American taxpayers a lot of money for no particularly good reason. Fortunately, we have moved to a new procurement system, and while that is part of the title of the slide, this slide could also be entitled Why I Love Al Gore. So the media didn't focus on this because government contracting and reforming acquisition is not really a sexy topic. But under President Clinton, then Vice President Gore created a task force, National Performance Review. It was later renamed the National Partnership for Reinventing Government, and that radically reconfigured government procurement. The task force proposed 1,200 changes to better serve customers. So that means both government agencies and the public. Basically, Gore's task force found a way to simplify the whole system so that you don't need 9 pages of blather to buy ashtrays. Not that I think the government is buying ashtrays anymore, since you cannot smoke in government buildings. Well, it's probably buying certain ashtrays for outside. So that task force got rid of a ton of unnecessary regulatory requirements that really were burdensome to both businesses and also government agencies. The task force fostered competition and competitiveness by bringing in certain commercial practices. It encouraged plain English documents. We still really haven't totally gotten there, but it is a lot easier to read government solicitations and government contracts now than it was back in the day. It also encouraged the use of technology to widen access to federal services and federal information. One of the things that Gore's task force did was actually spearhead electronic tax filings. So we can submit our, tax returns every year electronically rather than having to mail a physical copy to the IRS. So in our new procurement system, we have performance metrics so that agencies can be evaluated and held accountable for their procurement decisions. The new system also empowers frontline workers by giving them more leeway to purchase commercial items under a much more simplified acquisition scheme. Gore's task force set forth fundamentals of government contracting. task force said government contracting has to be competitive, accountable, and transparent. The public should know what the government is buying, why it's buying it, and for how much. So during this overhaul of the procurement system, the task force really thought through the issues, and it really streamlined a lot of our procurement processes. And as a government contracts attorney who has spent a couple decades now working with the federal acquisition regulations, I believe that the majority of policies that underlie our federal procurement system are very sound. Like, we've got a good system in place. The problem is with implementation. That is familiar throughout government as well as throughout the private sector. It is the implementation stage where problems tend to crop up. Our system is also facing problems really stemming from a lack of institutional knowledge and a lack of bench strength. Beginning back in the Reagan years and continuing through multiple presidential administrations of both parties, there have been layoffs, retirements, and hiring freezes that have resulted in a shrunken, weakened federal acquisition workforce. So currently, we don't have enough people to oversee the contracting process. But the contracting process is not going to stop, because without it, we would not have a functioning government. If you want to see what the government buys, you can actually go to usaspending.gov. Everything that the government purchases is supposed to be on there, and you can search by contractor name, you can search by agency. That was really a big push towards transparency. Now, after Citizens United, there's a little uncertainty about transparency in contracting, although from what I have seen, the transparency concerns related to Citizens United are primarily more on the political side and not necessarily on the procurement side. But we definitely don't have enough people to oversee the procurement side. Now, I don't mean to imply that government contractors are out there running wild. We do have procurement and acquisition laws that serve to limit agency discretion in the area of contracting and also limit a contractor's authority. So one statutory limit is appropriations legislation. That is how Congress gives an agency funding. So if Congress appropriates funds to, say, the National Institute of Health and says that those funds have to go towards cancer research, NIH has to use them for cancer research. They cannot use those funds to study anything else. Another statutory limitation is the Anti-Deficiency Act, which states that no one in the federal government can obligate the government to make payments without appropriations legislation. And this is why federal contracts, as well as grants, are issued in one-year increments. Congress only appropriates 1 year at a time on a fiscal year basis. The reason that we have government shutdowns is when Congress fails to appropriate funds and the agencies simply are not allowed to function. They don't have the authority to do so. There are also regulatory limits on an agency's authority to acquire goods and services, and the contractor's authority to work on behalf of the government. Many of these limits are established by the FAR, the Federal Acquisition Regulation. I am not going to discuss the FAR in this lecture, but I will post a separate, somewhat older lecture on the FAR in case you're interested. Please do not feel that you have to go listen to that lecture or read through any of the slides, but if you wind up in some type of contracting position or you just have a hankering to know more about federal acquisition, it'll be there as a resource for you. Now, there are some other limits that are not statutory or regulatory on agency contracting discretion. Core governmental functions are not supposed to be outsourced. That policy was established back in the 60s by OMB Circular A76. So that's the circular that says that we rely on the private sector for commercial services. A76 used to require really complex decisions on whether the government should perform certain work in-house versus contracting work out, but Congress placed a moratorium on what we would call these A76 competitions after a Washington Post investigation about neglect at the Walter Reed Medical Center raised concerns. So Congress really became concerned about the possibility that contractors were performing inherently governmental functions and about the inadequacy of oversight mechanisms. Additionally, OMB has found that excessive reliance on contractors erodes the government's in-house capacity, so agencies become unable to perform critical functions, and that obviously undermines their ability to carry out their statutory mandates, to accomplish their missions. So it is A76 that defines inherently governmental functions. You can see that these are things that are discretionary exercise of government authority, like criminal investigations or prosecutions, managing any type of program that requires value judgments, so on and so forth. So make sure that you understand that definition of inherently governmental functions, because that's what we're going to be discussing this week. Now, we have a huge range of different types of contractors, from a one person small business up to gigantic multinational pharmaceutical companies. Government contractors include companies, nonprofit organizations, non-governmental organizations, universities, state agencies, so on and so forth. And all of these contractors typically break down into contractors who provide services and contractors who provide equipment and other goods. In traditional personal services contracts, the government retains the function, but the contractor staffs the effort. So some of those would be, IT support, research, facilities, maintenance operation, food service, etc. And traditional industrial contractors would handle large-scale building and manufacturing, anything from making uniforms to building aircraft carriers. That works well for us. We as the public, we benefit from having Boeing and Lockheed and other companies compete for government contracts, and we benefit from not having to pay the building and maintenance costs for these giant manufacturing facilities. Now, however, defense contractors have a new role in the military-industrial complex. So when Eisenhower made his famous farewell speech and mentioned, growing concern about the military-industrial complex, he was worried about more traditional service and industry contractors. He was concerned that the federal government wouldn't provide appropriate oversight, and the country would find itself in a situation where big contractors kept pushing us into wars, because wars can be very, very profitable for certain companies. It is actually, the situation we find ourselves in now, actually worse than what Eisenhower was envisioning, because the military-industrial complex is much more invasive. In part, it's invasive because it places contractor personnel on the front lines. And that might be the front lines of a physical battlefield, or they could be piloting unmanned drones, thousands of miles away from a war zone. So the US and other countries have begun outsourcing what really would appear to be inherent governmental functions that relate to military and intelligence agencies. And this is not just about privatized military soldiers. General Dynamics won a $10 million contract from U.S. Special Operation Command's Psychological Operations Unit. General Dynamics got this contract to create websites to influence foreigners' views of U.S. policy. So that isn't all that different from the Russian troll farms that we are having trouble with today. Now, I am very supportive of government contracting. I am a government contracts attorney. So my career has been based on it. But I do think that we have gone overboard in certain areas, and we do need to rein in government contracting, or at least have a public discussion about it. The American public has never really had that discussion. We've not really had a real debate over whether extensive outsourcing is a good thing. And in part, we haven't had that debate because the public does not understand the magnitude of contractor use, and the public usually only hears about it due to newsworthy incidents. Most people also don't realize the oversight challenges involved in today's contracting system. A lot of agencies rely on contractors to oversee other contractors. And in part, that is because the sheer number of contractors makes efficient oversight difficult, if not impossible. A single federal contracting officer might be in charge of hundreds or even thousands of contracts. And because a lot of those contractors are operating in dangerous conditions, disaster zones, war zones, the contracting officer can't just easily pop in and check on them. And so our government's overdependence on contractors has been a big concern for a while. We are just no longer certain that our bureaucracy can survive without contractors. We know that we have a problem with hollow agencies. Those are agencies that rely heavily on non-federal personnel to run them. There's also concern about effective public service in a profit-driven model. Obviously, government contracting companies have to make a profit, otherwise they won't remain in business. But when they are carrying out things that are more inherently governmental, we never really want a profit-driven model to override effective public service. And we have to worry about ethical considerations like the undue influence that contractors can have on public policy. So for example, the military services industry is now so deeply intertwined with both service and support components of the US military that if we got rid of all the contractors, we would basically have to rebuild the military from scratch. And that would include having to reinstate the draft. And the same is true in other fields. We have these increasingly powerful large companies that are really not accountable to the general public. We don't vote for them, but they do have an outsized impact on policy. So even though this week's readings about dependence on government contractors, they're from a few years back, the situation has not improved since then. It has actually gotten worse. So this overdependence on contractors and the impossibility of providing effective oversight of all of our contractors has led to various government contracting scandals throughout our history. I've highlighted just a few here. First, so you don't think that these are all modern scandals, there was the Teapot Dome scandal back in the early 1920s. And in that situation, the Secretary of the Interior, Albert Bacon Fall, leased Navy petroleum reserves to private oil companies at very low rates and without competitive bidding. He also used the military to scare off competitors, so sometimes at gunpoint. Eventually, he was convicted of accepting bribes, and Secretary Fall took quite a fall. He was the first cabinet member to go to prison as the result of a contracting scandal. And until Watergate hit in the 70s, the Teapot Dome was basically the most sensational scandal in US history. It was the first scandal that really drew public attention to government contracts, but it was certainly not the last. So you may have heard of the Fat Leonard scandal. That is a contracting and corruption scandal that is at the heart of an ongoing investigation within the US Navy. And at the heart of that scandal is a company called Glenn Defense Marine Asia, run by Leonard Glenn Francis, aka Fat Leonard. Fat Leonard provided cash, booze, luxury items, and prostitutes to the Navy's 7th Fleet. And in return, he obtained classified or otherwise confidential information about other government contractors. And then he used that information to benefit his own business. So for instance, he would redirect US aircraft carriers to refuel in ports that he controlled so that he could make more money. And to date, US federal prosecutors have filed criminal charges against over 30 people in connection with the Fat Leonard scandal. At least 10 commissioned Navy officers and 2 civilian Navy contracting officers got wrapped up in that. 22 of the people charged, including Fat Leonard himself, have pled guilty. And that scandal really continues to engulf the Navy's 7th Fleet. So if you haven't heard of it, it is definitely worth reading about. It's pretty fascinating, all of the shenanigans that were going on there. There is also the Whitefish Energy scandal, in which Montana-based Whitefish Energy Holdings got a sole source contract for $300 million to restore Puerto Rico's electrical grid after it was decimated by Hurricane Maria. Now, sole source, also called no bid contracts, these are very rare, they are very risky, and they're supposed to be used only when there really is no sufficient competition for the contract. In the Whitefish Energy case, there were other companies that could have done the work, but they never even had a chance to bid. And Whitefish Energy just so happened to be based in the hometown of then Secretary of the Interior Ryan Zinke. So you can see Secretaries of the Interior apparently just get caught up in government contracting scandals regardless of century. The owner of the company was also friendly with Zinke. And so this sole source contract, it raised a lot of eyebrows, particularly when Congress realized that Whitefish Energy only had 2 full-time employees when Hurricane Maria hit, and it had almost no experience responding to natural disasters or rebuilding damaged energy grids. So how did it get a $300 million sole source contract? Finally, there is the JEDI contract. That is one of our most recent government contracting scandals. It is a dispute over the Pentagon's $10 billion cloud computing infrastructure called JEDI, that is Joint Enterprise Defense Infrastructure, although I tend to suspect that most of our government agencies like to name things after pop culture if they can. So the Pentagon was just about to award that contract to Microsoft when controversy hit. Again, members of Congress became concerned that the request for proposal, was written in such a way that it favored Microsoft, which at the time, and I believe still is, sort of running behind both Amazon Web Services and Oracle in terms of cloud computing operations. So there were allegations that procurement officials within the Pentagon had personal financial interests in the JEDI procurement, that government officials were disclosing company confidential information to competitors. There's even some allegations that President Trump really pushed for Microsoft because he did not want Amazon to get the contract because of his ongoing personal beef with Amazon CEO Jeff Bezos. So after a year of lawsuits, bid protests, and scrutiny, the Pentagon recently decided to re-award that $10 billion JEDI cloud contract to Microsoft, but that is now under a court injunction. It has all been held up because Amazon and Oracle want to continue their protests. So those are just a few scandals. I've got some stuff posted in our Canvas classroom about them if you would like to read more. Okay, so this week we are going to discuss inherently governmental functions and how you feel about the potential that those are being outsourced to military and intelligence contractors. Also due this week is Case Brief 2. We have changed it up. We are going to just kind of follow along with Loving v. Virginia and take a look at Obergefell v. Hodges. You only need to read and brief the majority opinion. That is like just around 30 pages. You do not have to worry about the dissent. Obviously, feel free to read it if you want to. Not required for your case brief. All right, thank you so much. Thanks for listening. Have a great week. I will see you on the discussion boards.